Can a landlord deregulate a rent-controlled apartment by stipulation that does not allow a right to appeal? To find out, you have to read Liggett versus Lew Realty, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Liggett versus Lew Realty. The citation for this case is 2024 New York Slip Opinion 3378, published by the New York Court of Appeals on June 20th of 2024. The issue in this case is whether a landlord can get around the rent control system, rent stabilization system, through the use of a stipulation between a landlord and a tenant to obtain a rent deregulated apartment. To understand the background, to understand this case fully, it's a little complicated, the law and the facts, but to understand the case, you have to understand that there's a system called rent control and rent stabilization. In post-World War II, New York City, there was a fear that the rent was going to be out of control and people wouldn't be able to live in New York City anymore. So they passed a law called the rent control system, which only applies to housing built before 1947. It has very strict controls, strict limits on rent amounts, and eviction protections. But then they passed something called rent stabilization, which gives landlords more leeway to increase rents within given limits. And rent control apartments that become vacant become rent stabilized. The Rent Stabilization Code is New York City Rules and Regulations 9, Section 2521.1. The important part of that area of law is about what the amount of the legal rent would be after an apartment stops being rent controlled. And that specific statute says, for housing accommodations which on March 31st, 1984 were subject to the city rent law and became vacant after that date, and which are no longer subject to the city rent law and are rented thereafter, subject to the rent stabilization law, the initial regulated rent, this decides what the rent will be after rent control. The initial regulated rent shall be the rent agreed to by the owner and the tenant and reserved in a lease or provided for in a rental agreement, subject to the provisions of this code and subject to a tenant's right to a fair market rent appeal to adjust the rent, okay? And the only other thing you have to know as background is that under 9 New York City Rules and Regs 2200.15, it states that any agreement by a tenant to waive the benefit of any provision of the rent stabilization law is void. You're not allowed to make an agreement that voids or deprives tenants of the protections of the rent stabilization law. Okay, what are the facts in this case? The facts are that there's an apartment that's subject to this case. So it's built before 1947. It's a rent-controlled apartment. In 1984, the initial rent registration documents indicated that it was rent-controlled, and the rent was $141.23 a month. That's how cheap some of these rent-controlled apartments were, $141 a month. The tenant of the apartment was a person named Edward Brown, who then died. When Brown died, a person named Edward McKinley continued living in the apartment. He said he was his roommate, or he claimed he was a holdover tenant and wanted to continue living in the apartment under a transfer provision of the rent control law that allows him to continue living under the same rent control apartment in very specific circumstances. The defendant was the owner of the building, Lew Realty, and they filed a court case against McKinley, that's that holdover tenant, to evict him, saying, you're not legally here, get out of here. While that case was pending, they reached a settlement between Lew Realty and McKinley, a stipulation, an agreement between the parties. In that agreement, they agreed the apartment was no longer subject to rent control, but was rather rent stabilized. They agreed that the initial legal rent would be $1,650 per month, but that they would only make him pay $650 per month. And with increases in with increases of rates that are allowed by the rent stabilization law. And finally, and this is the important part of the agreement said McKinley's not allowed to appeal that initial rent amount, that initial $1,650. He's not allowed to go challenge this with the FMRA, that challenge provision that allows a person for the fair market rent appeal. So then, a year later, McKinley left the apartment, and eventually in 2020, Liggett, who's the petitioner in this case, took over as the tenant of the apartment under a market lease. And they claimed that it was subject to a luxury deregulation, that it was no longer rent controlled or rent stabilized because the rent would exceed $2,000. They tried to raise the rent at that point. claiming the apartment had been rent stabilized and she's entitled to a rent stabilized lease, overcharges, and attorney's fees. At that point, Liggett sued and said the apartment's rate was improperly arrived at. It was not actually $1,650 because they didn't follow the rent stabilization law. So it never had properly been taken out of the rent control system. And at that point, it goes to court. The Supreme Court denies a motion to dismiss, holding that the stipulation was unenforceable because it waived the protections of the rent law because of that provision that said you can't appeal. It goes to the appellate division and they reverse. They reverse it and they dismiss it, saying that although an agreement by a tenant to waive the benefit of the rent control law is void, it doesn't apply to McKinley because he was not an established tenant. That law that says you're not allowed to waive these rules apply to tenants. And McKinley was not an established tenant. He was a proposed tenant. He was hoping to be a tenant. It appeals to the Court of Appeals, and they reverse. They say that this was void as against public policy. You're not allowed to make a stipulation that avoids going through the proper channels. In particular, to arrive at an initial legal rent, you have to satisfy all those conditions. You have to have an agreement. It has to be a person, the thing the person pays. You have to file it, and they have to have the right to appeal. And here, they deprived McKinley of the right to appeal, and therefore it was void as against public policy. And therefore, the statute of limitations is not a bar to it. The fact that he wasn't a tenant is not a bar to it. It was void. Void ab initio, void from the very beginning. And therefore, it was not properly deregulated. They remand it back to see if there's some argument to be made about it being properly deregulated a different way. And that's the case of Liggett versus Lew Realty. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.